Imagine this. You are one of the most respected directors in India. Companies want you on their board, investors trust your judgment, promoters seek your advice. Every month, another listed company offers you a directorship. Sounds like a dream? Maybe. But now imagine this. One more appointment could make you non compliant with SEBI regulations. Yes, just one additional board seat, and suddenly a highly respected director may violate Regulation 17A. So the question is, how many listed company boards can one person legally join? Can an independent director sit on 10 boards? Can a director accept every offer that comes his way? And why did SEBI decide to restrict the number of directorships? Stay till the end because I will show you the board seat formula used by company secretaries and nomination and remuneration committees before every director appointment. Welcome to Corporate and Securities Law Compass, the channel where corporate laws, SEBI regulations, FEMA, corporate governance, and secretarial practice are explained through practical examples and real life compliance situations. If you are a company secretary, director, compliance officer, CA, CMA, lawyer, investor, or law student, subscribe now. Let's begin. Quick question. What is more dangerous? A director serving on one board or a director serving on 12 boards simultaneously? Most people immediately say 12. But why exactly does SEBI care? That answer explains the entire purpose of Regulation 17A. Why did SEBI introduce Regulation 17A? Think about the responsibilities of a director. A director must attend board meetings, review financial statements, evaluate risks, monitor compliance, review related party transactions, participate in committees, protect shareholder interests. Now imagine doing this for 10 or 15 listed companies simultaneously. Would meaningful oversight still be possible? SEBI believed excessive directorships could dilute effectiveness. Therefore, limits were introduced. The core rule, Regulation 17A, establishes the maximum number of listed company directorships a person can hold. The objective is simple. Quality of governance is more important than quantity of appointments. Important timeline. From the 1st of April 2019, a person could not be a director in more than 8 listed entities. Then, SEBI tightened the requirement further. From the 1st of April 2020, a person cannot be a director in more than 7 listed entities. Remember this. The current limit is 7 listed entities. Quick test. Suppose Mr. Sharma is already a director in 7 listed companies. An 8th listed company offers him a board position. Can he accept? Think about it. The answer is no, because accepting the appointment would violate Regulation 17A. Simple. Now comes the provision that creates the most examination questions: independent directors. And the rule is even stricter. Independent director limit. SEBI recognizes that independent directors perform a special governance role. They are expected to challenge management, review governance, protect minority shareholders, monitor compliance, evaluate risks. Therefore, independent directors require sufficient time and attention. The special rule. A person cannot serve as an independent director in more than 7 listed entities. This is a favorite examination question. Many students confuse it with ordinary directorship limits. Don't make that mistake. Practical example. Suppose Mrs. Mehta serves as independent director in Company 1, Company 2, Company 3, Company 4, Company 5, Company 6, Company 7. Can she accept an 8th independent directorship? No. The appointment would violate Regulation 17A. Why this rule matters? Let's be practical. An independent director is expected to read board papers, review audit committee materials, understand risks, evaluate governance issues, attend meetings, challenge management decisions. This requires time. SEBI wants active independent directors, not symbolic appointments. Real life governance question. Would you trust an independent director who carefully studies one company's affairs, or one who sits on 12 boards and barely has time to review agenda papers? This is exactly the governance concern SEBI wanted to address. Golden memory formula. Remember only two numbers. Director equals maximum 7 listed companies. Independent director equals maximum 7 listed companies. If you remember the number 7, you will answer most Regulation 17A questions correctly. Secretarial audit checkpoint. Whenever a company proposes a new director appointment, the company secretary should verify existing directorships, independent directorships, alternate directorships, compliance with Regulation 17A before the appointment is finalized. This is a standard governance review. Practical case study. Imagine a company appoints a famous corporate professional. Everyone celebrates. Press releases are issued. Investors welcome the appointment. Then compliance verification reveals the proposed appointee already serves on 7 listed company boards. Result: the appointment cannot proceed unless compliance is maintained. One compliance check changes everything. Examination shortcut. Question: what is the maximum number of listed entities in which a person may serve as director? Answer: 7. Question: what is the maximum number of listed entities in which a person may serve as independent director? Answer: 7. Memorize these two answers. Examiners love asking them. Today we learned purpose of Regulation 17A, maximum directorship limits, 7 listed entity rule, independent director limit, governance rationale. Practical compliance checks, secretarial audit perspective, examination shortcuts, the 10-second memory trick. Too many boards, too little oversight. SEBI says maximum 7. That's Regulation 17A. Before you leave, answer this question in the comments. Would stricter limits improve corporate governance? A. Yes. B. No. Comment A or B below. And if you've completed the entire Regulation 17 series so far, comment Board Governance Master, so I know you've reached this stage of the masterclass. In the next episode, we will continue exploring SEBI's corporate governance framework and the practical compliance challenges faced by listed entities. Subscribe now to Corporate and Securities Law Compass. Thank you for watching. See you in the next episode. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.